Good morning, good
Good
morning.
morning.
Welcome. It's a beautiful day. It was raining yesterday, but we have the weather, a beautiful weather today. I think it's a little windy, but I'm so glad you're here today. I'm excited about this moment we're spending together. Good morning to those online. So glad to have you with us as well. My name is Attorney Jumoke Oladapo from Ivy Law Office. We're here for a 2-hour educational session today, and the topic is bills, trust, and appetizers. So for those in house, I hope you got something to munch on, and it's about estate and legacy planning. How to avoid the three biggest mistakes in estate planning. This is put together by our office, Ivy Law Office. You're located right here in Greenbelt, opposite this building at 6305. Those three set of buildings over there. 6305 Ivy Lane, Suite 605. And we have been serving our community for about 13 years. So we're glad that we have an opportunity to continue the same through offering this presentation. Thank you so much for coming. We're going to be here for 2 hours, and I want to make the best use of your time today. So, the best way to learn, because we're going to learn a lot, is for us to please turn off our phone or put it on silent. All right? So, please turn off your phone or put it on silent. You deserve this time for yourself and also for your loved ones. All right? A few housekeeping. So, this is just an educative session. It does not create attorney-client's privilege. All right? And because we're streaming live online, I'd like you to keep your personal information to yourself when speaking or when asking questions so that nobody will know who's speaking on Facebook. All right? So make sure you don't give too much personal information when you're asking questions. Also, you become our clients when you send an engagement letter. So this does not make you one of our clients now until you retain us, engage our services, then we become your attorneys. Also, I would like to answer all questions at the end of the presentation. So we have a notepad in our folder. Please jot down all your questions and we'll answer them at the end. However, when I'm speaking, I want it to be a little interactive. So I'll be asking for feedback from time to time. I'd like your engagement during those sessions, those times, okay? So that we'll make it as interesting as possible. And we have in our folder a couple of materials. In your blue folder, we have a green worksheet. This is a very important piece of paper. First of all, I'd like you to complete the first section. It's about yourself, and whatever information you provide there will be confidential. All right? We're not going to share with anyone. We'll just like to get back in touch with you afterwards. All right? Then the next session says, please tell us about your need. So during the presentation, I'm going to be asking questions like, based on what I said, would you like to give your kids money and let them inherit at 18 years old? So if that resonates with you and you think your answer is yes or no, you check the box. All right? And we'll go through some of those things. Whatever relates to you, you check the box. Then the next session says, how can we help you further? What's your next step? So some of our next steps will be asking you to schedule a family wealth planning session so that you can start your own estate planning. Another will be maybe you'll need a call back from us to speak further with me briefly. Another will be if you'd like to have be part of our e-newsletters. We send out e-newsletters regularly, and they have a lot of information about estate planning. You can check that box. And the next will be if you'd like to have a copy of our best-selling book, Wear Clean Underwear. We have e-copies. That title is fascinating, am I right? But it's a book about legacy planning. So and there are a lot of stories, interesting stories there. So if you'd like to have an electronic copy, we can send that to your email. So you check that box. And would like to know how well we can serve you and the feedback about the seminar. At the end of today's meeting, would like you to please submit this. All right? Complete it and submit back the green worksheet. When you submit this green worksheet, we're going to give you some gifts, and those are what we call the golden ticket. All right. So stay tuned to the end. Be here to the end, and you're going to get golden tickets. For those online, towards the end, we're going to give you our phone number. Just type in your information and say, I was here till the end with your name on. Well, don't put your name. And maybe your first name. And we will get in touch with you, or you get in touch with us so that you will get your own golden ticket as well. So, some more information about the golden ticket. Complete your worksheet. So this certificate is a gift certificate. One is for $750, and it's going to be given to you when you submit this. It's an invitation to have a complimentary one-to-one meeting with us. You will sit down with me. If you're married, you come in as a couple. Okay. When you come in, we're going to discuss about you, your assets, your loved ones, and how to protect them. This time is precious because it's 2 hours. The value is $750. So if you'd like to have one, we're going to give it to you when you submit this, and you can schedule a family wealth planning session. You'll schedule a family wealth planning session with $20 to secure your appointment, and also a commitment to complete the intake sheet we'll be sending to you and submitting it back. Also, when you schedule that appointment, so one is picking it up and getting the $750 coupon to use later on. The second one is taking the action to schedule. And when you schedule, we'll give you another gift certificate, which is a $250 credit towards any plan you decide to do with us. And in addition, we'll give you a digital asset checklist. How many of you have like a lot of online accounts, bank accounts, phone accounts, 1,000 usernames and passwords? So we just want people to be more organized so that those things are not lost. And we'll give you something to work to put those in place. And those are real part of planning. All right. So all that being said, we want you to please stay tuned to the end. So the next thing I would like to ask you is this. How did you find out about the seminar? Did you get this in the mail? Did anybody get this in the mail? You did? Any other person? All righty. How about Facebook ad? You got it. All of you. All right. How about e-newsletters? I think you all answered the question. if you found us on Facebook, please type it, and you're online, type how you got to find out about the seminar. Would love to know. E-newsletters, personal invitation, Facebook, and also the mail, the postcards. We'll want to know what is working so that we'll be able to emphasize more on what works. But anyway, whichever way you found out about us, welcome. We're glad you're here. Thank you so much for honoring the invitation. It's going to be worthwhile, all right? And by the end of today's session, you'll have learned a lot and motivated to do something that will be beneficial to protect yourself, your assets, and your loved ones. So I'm wondering if you really know me. You don't know me that well yet, but again, I'll say my name because it's not a popular name. My name is Attorney Jumoke, that's the way it sounds, Oladapo. All right. So for short, Jumoke. Some people call me Jumoke. Some people call me Jumoke, but it's Jumoke. Alrighty. So I'm the managing attorney at Ivy Law Office. That's our office, and also the founder of Ivy Law Office. We've been privileged to serve our community, as I said, for 13 years, and over those years, we were privileged to have a lot of success stories. All right, we've served thousands of people with 98 or 99% success stories. So we know what we do, and we do it well in service of our communities. And as a result, we have a lot of accolades, a few of which are named as the Lawyer of Distinction, with the top best attorneys for immigration. We do immigration and estate planning, okay? So for immigration, we're named the top 10 best in Maryland. Also, our law firm was named the top 10 in Maryland. We have a lot of 5-star Google reviews, all right? Those ones are not cheap to get because if you're not a good person, you'll get bad ratings, all right? So thank you to all our clients that gave us good ratings on Google, and we have like over 80 of them, 5 stars, all right? Also, for estate planning specifically, we have a title we've been licensed as a personal family lawyer. A personal family law is not for family law, but it's to serve families, all right? And what that means is we have a special training for estate planning, and we serve our clients with a model that we don't just create plans. We don't just draft plans and give it to them to go and sort themselves out. But we make sure that we develop a relationship with them and make sure that their plans work when needed. So we do comprehensive planning, we serve our clients with excellence, and we make sure things work for them. Alrighty. So we are personal family lawyers, and also we've been named as top 10 top attorneys on Avo. These and much more, we've been able to accomplish. And on a personal note, that's my family. I'm married and I have 3 daughters, and that's my mom over there. Thank you, mommy. I resemble her. So, and thank you so much for coming to support today. So, but why? My why is around my family, okay? When we plan for the people we love most. It's not just for ourselves, but we don't want to leave our family in a mess after us. We don't want to leave our family conflicting about us, all right? So that's my why, and I love them, and they're very supportive of me. Thank you to my husband, too. This is my team. This is myself, Attorney Wilberforce, Miss Moji, she's not here today. Miss Princess, she's at the door. And Miss Taya, hi Miss Taya. So we all serve our clients with excellence. All right, we work together as a team and we serve our clients with excellence. We have other people outside of the office. These are the people in office, and we have other people outside that work together to make the dream and the vision work. So thank you to all our team for working to make our clients like what we do. So the next question we have, I spoke about. All right, so make use of your notes. Also, we have some testimonials from our clients in your folder, and we also have a bio about me and what we do. And there's a takeaway worksheet that says probate and taxable estate worksheet. So that's just a brief for you to be able to put down a value for what you have that makes up your estate, okay, or your assets. But the most important document today is this green worksheet. All right. So a good question I'd like to start with is, do you currently have an estate plan? No. Is everybody a no? All righty. So the next question will be, if no, why not? Some of the reasons that we find people talk about are they're too busy. You're too busy. Does that resonate with anyone? Yes. Maybe you were too young or you're still too young. Does that resonate with anyone? Maybe before, am I right? A long time ago. Or you just think in your mind that it may be too expensive. All right. But you don't know what it costs, but it just says, oh, it may be expensive. So these are some reasons. But I want to ask my audience today, your why. Why haven't you done your estate plans? If you're online, you can put in the chat why you've not had your estate plan done. So I want one, two, or three people to tell me why not.
Kind of complicated, don't want to do it wrong.
Okay, kind of complicated, and she doesn't want to do it wrong.
I've heard from others just the expense that it is. So for me, it was the expense.
So it was the expense.
Mine's, I had one, but it was outdated. I didn't.
Okay, she had one, but it's been outdated. Thank you very much for your feedback. And all of you have valid reasons. These are reasons that people get it done. These are reasons why people have not had plans in place. So I have one person that had one before, which seemed to be outdated. So if yes, because she has one, why? What do you hope to learn today? Your reason is actually here because it's outdated. Mr. Can you pick that call? Or maybe you think, maybe some people did online documents, all right? And they want to find out if the online plans are okay. The LegalZoom, the Rocket Lawyer, the Susan Oman, what else? There are a lot of them online. The Wills and Trust. Or maybe you want to have a better understanding of this old thing called estate planning. Because sometimes it's a big one. People don't know what it's really all about. Some people, when I say, I'm an estate planning attorney, what comes to their mind first is real estate, But estate planning is not about real estate, buying a house. That's something else. Also, some people have fears, all right? And this is the biggest fear that we found out. Planning for it will hasten its occurrence. And that happens, I don't know whether anyone here has that fear, but I know people do, particularly people from diaspora, people from Africa. I'm from Africa. So a lot of people don't get their plans done because they think that when, and the most popular estate planning document people know about is will, all right? So people think that when they go to an attorney or have their wills prepared, they're gonna die soon thereafter. That's what they think. So they don't do these plans because they're always saying, I shall not die. All right? Or they are not ready to die. So they continue postponing and postponing and postponing until one day it's too late. And then they leave their families at mess. So if you have this hesitation or this fear, you need to deal with it because it's not necessarily so. All right? It's just like in the United States, when you buy a home, they tell you have homeowners insurance. Am I right? Does it mean your home is going to burn down the next day? No. Or when you have a car, they tell you have a car insurance. Does it mean you're going to get into an accident next week? No. Do you understand? But you have all this as preventive measures so that if something bad happens, you're well prepared. Am I right? So, these are other reasons or other myths about estate planning. First of all, it's for the old folks or the retired folks or those who are getting towards retirement. A lot of people I see are people in their 50s, something late 50s, 60s, 70s, 80s, you know. So people think it's for when you're old, but no, not necessarily. Or they say I still have plenty of time, When they're in their 30s and 40s, they say, no, I don't need that right now. But no, when you want to have a plan, starts with when you start having a family or when you start having some assets. So, for example, people after graduating from college and they start working, they have a home. Am I right? They buy a home. They probably get married, have children if they decide to. Um, their job gets them into 401ks and things like that. That's the right time to start creating a plan. So when you start having some moderate assets is when you want to start creating a plan. All right? So it's not for the old folks. So if you have some grandchildren, or no, not grandchildren, children, adult children, please tell them about it. All right? Because they need it. All right. Some other myth is I don't have enough. Or it's for the wealthy. I don't have enough. Who does that resonate with? No one here. But there's some people that will say it's for the wealthy. They think it's for the millionaires. But there are a lot of people that are not millionaires. Am I right? No. And you have enough. Everybody has something. All right. And we're going to get to know that soon. So, all you need is a modest asset. And some people think a will resolves everything. Does a will resolve everything? We will learn more about that today. But the answer is no. It's okay to have a will, which is the most popular legal document, but there are a lot more legal documents that estate planning that is involved in estate planning. So not just a will. We have a power of attorney, we have a healthcare director, we have a will, we have a table of interest, we have a lot of things. All right. So it's not just a will and it doesn't resolve everything. And we'll learn more about that today. So, are you here? Why are you here? You're here, am I right? Why are you here?
To help my mom establish her estate plan.
All right, thank you. Any other person? Why did you come?
It's just time to start explaining.
All right. Any other person?
To understand what is involved in estate planning from a totalistic view.
Okay. Does any other person want to say anything? All righty. So, if you're here to have the total assurance and comfort of knowing that your family will be well taken care of after you're gone, and they know what to do so that they're not left confused and in a mess, then that's a good reason to learn about estate planning. All right? The next thing is, if you want to have the peace of mind of knowing what will happen to your assets or how your assets will be distributed, how you want it to be distributed after you're gone and not lost to the government, you're here for the right reasons. That's part of why you plan. And the next reason, if you want to save on estate taxes, you're here for the right reasons. And I said that because USA likes taxes. Am I right? How many times? Just give me like 4 types of taxes you know about.
Sales tax,
Sales tax,
property tax,
property tax, income tax.
Yes.
Any other one that comes to my head is VATs, whatever that means, value added tax. You know all the taxes that has to do with estate planning, inheritance tax, federal estate tax, state estate tax. I call them probate tax. Somebody told me death tax. It just goes on and on and on and on like that. So, how can you avoid paying unnecessary taxes? If you want to avoid paying unnecessary taxes, you need to have an estate plan in place because there are vehicles in the legal instrument that can help you save on taxes if you do the right thing. All right. If you don't do the right thing, sorry, but if you use the right legal documents, you can save on estate taxes. All right. Also, part of estate planning has to do with self-care. All right. You making legal decisions and giving directives about how you want to be taken care of or who will take care of you in the event of incapacity. Not everything has to do with when you pass away. While you're still alive, if something happens to you, unfortunately, what will happen to your person? What would you like to happen to you? Who do you want to make decisions for you? If you want your wishes to be honored, then you need to put them in writing. So planning for incapacity is important, and that's still part of estate planning. All right? So I think if you put a stop right there, we've learned enough. Am I right? A good summary. But one more thing I want us to learn about today or hear about is when you plan, when you do a good estate planning, You have to make sure that your properties or assets are protected from being lost to the government. The government's Department of Unclaimed Property. In Maryland, there are over 700 million worth of assets lost every year. All right? 750,000 unclaimed properties account worth more than 7 or 8 million, including 66,000 new listings every year. Why? Because someone passed away and there was this bank account or this insurance policy or this investment account that the family members did not know about. And at the end of the day, because they didn't know about it, they didn't account for it. And it goes to the government after some time, lost. So, why would we want to have stuff and it gets lost? And our beneficiaries are not aware of that. So, as part of planning, estate planning in our office, we want to make it financially organized. So you pull together all your assets and and we put it as part of your plan so that when you pass away or you cannot speak or anything anymore, your family members will know what you have and where to find it. All right? And that's part of estate planning. And for those who are interested in hearing what I'm saying, there was when I started to put my estate plan together, this was one of the things I had to put in place. All right, an inventory of my assets. So I visited the site for the Department of Unclaimed Property and wanted to know if I had anything there. I typed in my information, and lo and behold, I saw my name. I was like, what could it be? Why is my name there? I'm not dead. I don't know. Then I started thinking, could it be an account that I had some years ago that I closed out? Did I leave any money there? Could it? I had no clue. All right. So I put in an application and went to the office. When I got there, I said I had a $500 check. And I said, where did it come from? And do you know what? It said, a check was mailed to me by a government agency. However, it was mailed to an address, my old address. Meanwhile, I've moved to another address. So the government went back to the sender. And because I did not claim it, I went to the Department of Unclaimed Properties. So that year I became $500 richer that day, thanks to that little search. How much more people that have passed away? Do you understand? How many accounts, bank accounts do you have? Or how many stocks accounts do you have? Does your family know about everything? Or your children? Maybe not. If they know about two, they're going to go, they're going to walk on the two. But if you have five, that means we might be lost, maybe lost. So make sure that you're financially organized. And a lot of traditional lawyers don't care about that. All right. So you need to make this part of estate planning so that your assets will not be lost to the government at all. Right. We're going to start using our green worksheet now. As we go along, please remember to complete. Then we will be the second section. Tell us about your need. All righty. So I was saying earlier, estate planning could be a big word for some people. So what really is estate planning? It's a simple definition I have here. And it says it's planning in advance and naming who you want to receive the things you own after you die. A good estate planning is much more than that. And I've spoken about things earlier this morning, am I right, that speaks about what estate planning should be about. Am I right? Alrighty. So, do you even have assets? Or do you have any estate? All right? Your estate includes your assets. And when I speak with some people, they'll say, I don't have much. I only have a house and a bank account. Am I right? But they have so much more because they forget about their cars, they forget about the furniture in their home, they forget about the life insurance, their retirement account, the checking account, the savings account, and the money market account, and the stock account, and maybe their second home and the home on the beach, you know, or even their personal possessions. Your personal property, like some expert told us in my BNI, is, you know, if you put your house and you turn it upside down, anything that falls down is your personal property. All right, thanks, Gerald. Thank you for that. So, when you turn your house upside down, what will fall off? Your furniture, your artwork, maybe your piece of jewelry, your shoes, your Gucci bag, your designers, your rings, what else? And so on and so on. All those are part of our assets, and all those are parts of our estates. So, who here has an estate? Raise up your hands.
Everybody.
Everybody, regardless of our age, we all do. No matter how modest it is, we all do. So, going back to my question and the myth, estate planning is for the wealthy. Is that really correct? No. Estate planning is for everybody, everyday people. Okay, so we've spoken about what your estate could consist of. So the question I have for you is this. Who needs your protection? Please, I'd like you to write on your piece of paper, who needs your protection? Everybody has a who because you're not an island. Am I right? You either have a child or a spouse or a brother or sister or cousin or grandparent or godmother and so on and so on. Who needs your protection? Also, I want you to write what needs to be protected. What do you want to protect? Because that's why you're here today, to learn about how to protect your assets or how to protect your people. So for me, my family needs my protection, right? Because I don't want to leave them in a mess after me. I want to have done things right so that they just pick up the baton and run with it without the court's involvement. In as simple and as easy a way as possible, without confusion, without conflict, and possibly, which is what I did, without the need of the court's involvement. All right? So, when you plan, you're not just planning for death, you're planning also for your life. It's in your best interest that you have an estate plan in place. And you need to have some mindset shift around the matter, okay? So it's a whole new experience when you put that in your hands to make a plan for yourself. And these are your experience. This is the experience you should have. One, when you plan, you're making informed and empowered decisions. Not a stranger, not someone else, not your family member. Do you understand? You are making the decision, not your child. You are making the decision, not a judge. You are making the decision, not a doctor. All right? So if you're interested in deciding about yourself and your loved ones and what you have, then you need to have a plan in place. Secondly, you're going to save your family thousands of dollars. All right? Thousands of dollars, because I'll show you what happens if you don't have a plan soon. So you plan now, or you plan, if you refuse to plan, there is a plan for you. Then assets are not lost upon death. We spoke about the Department of Unclaimed Properties a few minutes ago. Am I right? All right. Also, you protect your family's monies and dollars from outsiders. There are a lot of people waiting to have a share of your money. Believe me, all right? Attorneys are one of them. I'm an attorney, but we help people. But people don't help themselves ahead, we'll help them later. Some people don't listen and they get spent. They pay more when they don't plan. So people are waiting and creditors are there waiting as well. So why not protect your family's monies from outsiders as much as possible by having a plan in place? And also, you'll be able to have a lifetime of right legal and financial choices because you visit your plans from time to time. You update that. And the one that fascinates me most, which is part of our magic statement, is that we want you to keep your families out of court and out of conflict. All right? Our magic statement at Ivy Law for our estate plan practice is this: we help our clients' families we help our clients keep their families out of court and out of conflict in the event of incapacity or death through having proper comprehensive estate plans in place. And this is dear to me because there's so much advantage in planning ahead for your families to avoid court. I'm an attorney, and I know how gruesome it is when people go through legal process and litigation. I know people don't like it. When I'm preparing for cases, at times I have anxiety because I want to make sure this client wins. How much more the client? I don't know if you've had to go through litigation before, enjoys it. I don't know. They don't enjoy it. I know they don't enjoy it. And I'm fighting for them. It's not the best of enjoyment for me when I don't want my client to lose. Do you understand? So if you can avoid court, please do by doing stuff yourself, having a plan in place. So you want your plan to work for you when your family needs it. All right? There are a lot of people that don't have plans in place, so nothing works. Or they go through the complex process. And there's some people that don't do the right thing, and at the end of the day, the plan doesn't work for them. But we want you to do the right thing, and we want your plan to work for you. All right. So, for those who had plans, when was the last time you reviewed your plan or existing plan? When?
About 10 years ago.
10. You're not the only one that does that. Yeah. You know what people actually do? They get the plan done, have it executed, and either leave it in the lawyer's office or keep it in their safe deposit box or in their shelf where they keep important documents. And they forget about it, the check of the list. Am I right? Done. And they forget about it for years and years and years. Their life could have changed, aka their beneficiaries could have changed, their agents could have changed. In that, let's say you chose a child or a friend or whoever to be your agent, and the child passed away, or maybe a spouse and the spouse passed away. There should be a change in your plan, but people don't remember that because they go to traditional attorneys who don't tell them that you need to revisit and review your plans. Also, their assets may have changed. Okay? So, and also the law may have changed. So, when your asset changed, this is an example. There was a woman, she prepared estate plans years ago, like 15 years before she passed away. Like a lot of people do, she kept it away. When in a plan, in a will, she had two homes, a primary residence, another home, and a bank account. She also had three children, and she made specific distributions to those three children. One home to one person, the second home to the second person, and the bank account to the third child. Now, 15 years passed away, and she passed away. They brought out our will. First of all, some people don't even know where to find the original will. The lawyer had either been disbarred or had closed down business, and they did not get a letter from the lawyer that come and pick up your documents because we're no longer in practice. And they now start looking for where's the will, where's the will, where's the will. That happens to a lot of people, which shouldn't be. All right. So when this woman passed away, fortunately, they found the original will. Now it's time to execute the will. What the will says. Unfortunately, the second home had been sold. The bank account was already closed down. So the only asset left was the primary residence that only one person was going to have, one child was going to have. And you know, that child was selfish. She was living in that house, anyways, and she did not want to refinance to share proceeds with the siblings. She wanted to continue to have it all. It's hers, am I right? That woman, unfortunately, in unintentionally too, already disinherited two of her children. Do you understand what I'm saying? Was that her intention? Maybe not. Why? Because she did not review her plans when she sold the home. And to make matters worse, the personal representative was the person that she gave the bank account to. He wasn't going to get anything, anyways. So he decided that he was not going to do his job as a personal representative. So the sister had to go to litigation because she wanted title to the house. Title wasn't going to pass because the PR wasn't doing his job. So they started fighting against each other and had to go to court for the court to resolve the issue. And, and so on and so on. When the mom prepared the will, she prepared the will because she wanted things to work out for her children. Am I right? But was that what happened? No. So when you have estate plans done, don't just do it and keep it away. review it from time to time. We recommend at least reviewing your plans every 3 years. If nothing has changed, great. If there is a change, then speak with the attorney, estate planning attorney, on what can be done to make your plans up to update on your plans. Okay? There are incidences where agents, agents change, or where someone named her friend and she's already fallen out of love with that friend. Or maybe someone named his spouse and the spouse already passed away. So update your plans from time to time as needed. Or maybe you just got a new property and you want to make sure the property is also protected. Do you understand what I'm saying? Did I make my point clear? So don't just have a will, keep it away and update your will or make a new one if you have a will. But estate plan is more than a will. Am I right? So update your trust or other forms of estate plan when you need it. So all that has been said, the next question for those who don't have a plan is, you don't have a plan, what is the state's plan for you? Because it's not co sera, whatever will be, will be. A lot of people are living their lives like nothing is going to happen, they don't care. But if you don't care, there's someone that cares about you, all right? And that's the state. And they don't really care about you, they care about your money, all right? So the state's plan for you is the court process. When people pass away, the court process is called probate. When someone is incapacitated, the court process is called guardianship. All right? So let's talk about incapacity first. While you're alive, if something happens to you, you see car accidents on the road like almost every week. Am I right? Some survive, some don't. So let's assume this person had a car accident and was taken to the hospital and had to stay for weeks in the hospital. Or maybe the person gets into a coma. Who is going to continue running your affairs? The bills will continue running, am I right? You still have to pay your mortgage, you still have to pay those utility bills and and credit card accounts. Who will do those for you? Is it the spouse that doesn't even know your username and password? Do you understand what I'm saying? And you have locks on your phone. You understand what I'm saying? Or is it a child that doesn't know what you have? Who is going to act on your behalf in the event of incapacity? A lot of people get stuck. Someone will have to go to the bank for them. And when they get to the bank will not answer because they'll say, you don't have a power of attorney. You're not authorized to transact on this person's behalf. So at that point, it's a little too late because that person is not, I'm assuming this person is in coma and is not responsive, but is not dead. You understand what I'm saying? So, or maybe the person survived and has a big disability and had to be taken care of. Or maybe the person had strokes. Or maybe the person have Alzheimer. Anything can happen. You need a guardian to run your daily affairs and to run your finances. All right. And it's important to have a power of attorney. That will prevent you from having to go through the court system because you've already chosen someone as your agent. Someone you know, someone you like, someone you trust. But if you don't have this legal document in place, then you go to the guardianship court. or they go to the guardianship court. And, we have families, am I right? We have families. So, let's say you're a woman, you have a spouse, you have a child, you have a sibling, or sisters or brothers. They all love you, they're all interested persons. And they may not always be on the same page. They all have your best interest in heart, but diversified opinions about how to take care of you. So, you may find more than one person showing up to be your guardian. And if they're at loggerheads with each other, so bad. All right? Because now they'll be fighting about who is going to be the guardian. Someone will have a good intention, someone will not. Someone is about, then the judge has to make a decision. And the decision the judge will make may not be the person you want. All right? The judge will want to pick who is the guardian over your person and who is the guardian over your assets or property. So, if you have two loved ones, the judge will look at their credit, their credibility, who knows how to talk better, it's what the judge sees, what's in your best interest, and make a decision. So let's say you want your daughter to help you and not your spouse. All right? But you didn't say that in writing. A lot of people think the default will be the spouse. Am I right? But not always so. I know this individual that happened to. Mother has a child outside of marriage, has a husband, so the husband is a stepdad. So, unfortunately, this woman got sick and had to be taken care of. At the end of the day, the husband wasn't allowing the daughter to take care of her mom. So the daughter went to court so that she can have the authorization to become a mom's guardian. And also the the husband went to court because he wasn't going to allow the daughter to be the guardian. And now, conflict. All right? They're loved ones. Is that what the mom wanted? No. As she got a power of attorney naming who she wants, that would have been avoided. Simple. So we need to name agents, not only one, but even alternate agents. So that if one person does not show up, the next will step up. Also, the judge may choose a person as the guardian over your person, but not choose that person as the guardian over your finances and assets. The judge may decide to choose an attorney. And do you know what happens? They'll be charging per hour. I know a story of a person, let's call the person Mr. Barber. Mr. Barber became incapacitated and his son applied for guardianship. He went to court. The judge said, yes, you can take care of your father, but you can't take care of your father's money. So the judge appointed a court-appointed guardian, a lawyer to help with the finances. So the lawyer has to make a decision about the bills, have to put out the bills, come to court every time. And when the lawyer was going to court, it wasn't going to court alone, it was going to court with 2 or 3 other people and charging. At the end of the day, there was so much depletion in that man's account that the lawyer said, we need to sell your house because you don't have money anymore. You need to move to somewhere else. And bad decisions about bad decisions. When the lawyer will charge, let's say, $200 an hour, and he wants to make money. Is that something right to do? Maybe not. But because the man did not make a good decisions about who the guardian should be, that was happening to him. So don't let this happen to you. Create a plan called estate plan, a power of attorney to take care of your finances, a healthcare directive to take care of your health needs. All right? So that you don't have to go to court and so that a judge won't be making decisions for you. The second process is called probate. Probate is where people go when their loved ones pass away. In Maryland, you go to the orphans court to the register of wills. I call it probate court. So, a lot of people pass away without having any plans. They don't have a will, they don't have a trust, they don't have anything. Am I right? And some people pass away with just a will. A power of attorney is effective for just when you're alive. You can't use the power of attorney when someone passed away. So the full stop for a power of attorney is at the point, while you're alive, not after death. So you need a will, at least. So someone who is called an interested person, if you don't have a will or a trust, an interested person, which could be your family member, will go to the probate court and say, this person passed away, we want to probate our estate or his estate. Now, if there are more than one interested person, the same story of conflict will happen. Do you understand? Because you did not leave any clear directions on who you want to help you out. Some people are in it for money, some people are in it for love. Some people have been to court before, and the person that stepped up to be the personal representative actually thinks that dissident's money was her money and she can use it anyhow she wants. Do you understand that she just stepped into wealth because and then other people came and litigated against her that she was abusing the fund. But if you choose the person that you know will be able to administer your estate, well, that will be avoided. Am I right? So for those who have a will, to choose a personal representative. For those who don't have a will, the court will choose someone for them. And the court will have to assign someone or appoint someone. But what I'm trying to say is this. If you pass away intestate, that means without a will or without an estate plan, where you go is the probate court. Also, those who pass away with just a will, where the people go is also the probate court. All right? A will actually take you to court. I said a will is like filing a lawsuit against yourself with your own money for the benefit of your creditors. So, make a plan, choose who your reps are, and avoid conflict. But what even happens? Do you understand? Look at this pipeline of water. When they get to the court, they're going to ask for an inventory. What does she have? Or what does he have? And those people will try to make a list of what they know. Am I right? Some things will be lost. I know someone that listed some things, and she had a life insurance that she'd already forgotten about. And unfortunately, the life insurance did not have a beneficiary listed. It went to probate. Now, when they get to probate, there are a lot of fees that needs to be paid. If there's an attorney involved, there's attorney fees. The personal representative or executor can get fees up to 3%. The attorney's fees can be statutory. All right? If you have a home, it has to be appraised and valued, and the appraiser will get the piece. You have court filing fees. You have bond fees. I've not seen one person that wrote bond is waived that the judge did not tell them to get a bond. And you have creditors. So the interesting part of it are the creditor piece of it, because it's hilarious. When someone passed away, one of the things that the executor needs to do, executor and personal representative is the same person, okay? Just different words or language. But the court will say, we need to do a newspaper publication and put the dissident's name in the newspaper and announce this person is there. It's not the obituary, okay? They'll announce that this person passed away. Creditors, hello. If she owes you money, show up and make a claim. And they're not going to publish it in the newspaper one time. They're going to do that 2 times, calling on creditors to come and take their money. How fair, how good is that? So, all this happens. At the end of the day, everybody will take their part of your asset before your beneficiary or before the judge signs off on it to say now your estate can be closed and your beneficiaries can get title to what you gave to them. That's a state plan for you. Is that cool enough? Is that something you like? No. You can do better. Now you have knowledge that if you don't have a plan, or if you just have a will, this will happen. And to make it not so good, it takes time. In Maryland, if you have a regular estate, it could take between 12 months and 2 years, 24 months, for an estate process to complete. That means your family, your loved ones will have to wait for that longer period of time before title pass over to them. Is that something you really will want? If you have options, no. Okay? So, that's the state's plan for you, but you have the ability to make better choices for yourself. Maryland probate is public. What does that mean? If a person passes away and the person has a will called last will and testament, the will is going to be put in public record. And anyone that cares to have a look can go to the courthouse and look at it. It's not even, it's even worse that it's online. So as part of my duties, I know where to go to get a copy of someone's will. So rather than make your will everything the world will see, if you have an opportunity, you want to make it private. If you have a will, the court will ask for it, the court will make it public. If you have a revocable living trust or trust is a private document, okay? And the court will not publish it. And it will still accomplish what you want it to accomplish. Also, we spoke about the time, 12 to 24 months for someone that passes away without an estate or someone that passes away with a will that goes through the probate. When you have a trust in place, it's as fast as your trustee, successor trustee wants it to be. It could be 3 months, it could be 4 months, a very short period of time. And it's also private. And the cost of probate is, first of all, you avoid court. All right? Then you minimize on costs, on a whole lot of costs. So I want you to go to your green worksheet. I've spoken about options. Your option either for your estate to go through the court process called probate, or if you want to keep your family out of court and your assets out of court's involvement, please check the first box. I want to keep my family out of court. This is someone's will. Do we know that person? It was pulled from public record. Those are people that either planned or did not plan, or their will was found under the chair.
Oh.
You understand? They had to go through probate court because they either did nothing or they did something that was not properly done. Also, when you go through the probate system or when your family goes through the probate system, the beneficiaries receive assets outrightly and unprotected. How many of us have children under 18? We do. So these are representing kids under 18. So let's say you have a home and you have, how many kids do you have? Under 18? 2. Let's say you have 2 under 18. All right? If something unfortunate happens to you and you sum up your assets and it's $500,000, when the estate is resolved, they're going to give the kids the money. All right? First of all, they cannot get the money until 18. And when they turn 18, they're going to hand them, both of them, over $250,000 each. Let's say one is 15 years old and the other is 18. What will an 18 years old child do with that money? Spend it. Even if the person is 21 or 23, most of them are not financially mature at that age. It could just be so much money for them to handle. They'll buy a car because now they know how to drive. Am I right? They won't think about getting real estate. They'll think about parties, helping friends, maybe not going to school anymore. What will they do with such an amount of money? Why? Because they're getting it outrightly at 18. So when you have a plan in place or when you just have a will, that's what happened. So you want to have a trust that gives you some level of control over what you're giving to your children and how you're giving it to them and when you're giving it to them. For example, if you have a trust, you can say, I'm giving this monies to my kids in ages and stages. That's what we call it. So you can say, I give part of it to them at 21 and let them go to school. When you graduate, I give you another part of it. And maybe when you're 30 or 35 or 40, however you want it, I give you the remaining. So they become financially mature along the way, and you're not just ruining their lives with the gift you're giving to them with the inheritance. There's someone that when his father passed away, he left his life insurance of $150,000 for him. That man was given 50,000, at 18 years old. He decided to just waste his life away. He didn't go to college until he became 30 because he was given the remaining soon thereafter. Do you understand? Those are bad plannings. And I know another person, when we talk about unprotected, this is what it means. You give it to the child, it's in the child's name. Am I right? Let's say this child is a young female, 19 years old, got $500,000 from a parent, decided to get married. Now she's in love with her husband and created a joint account. So she put the money in the joint account. Or maybe the dad left the home for her and then the both started living in the home. Am I right? They did some maintenance and the man did some improvements on the home as well, spending the money together, the inheritance money. Something happened and they fell out of love. Unfortunately, they had to go through divorce. At the divorce court, that inheritance money became a joint asset. And the husband had to get $250,000. Why? Because the money was commingled. So it came to the daughter unprotected in a personal name. However, something better could have been done by putting that money in a trust so that it's not even in the daughter's name. So if anything happens, you're protecting your children's inheritance from creditors and from lawsuits. That's a better way to plan. Do you understand? So don't give inheritance unprotected. That's something I'm trying to get to. So let's get back to our green worksheet. The second part says, I need to make sure my kids don't inherit money at 18. If that applies to you, please check that box. Or maybe yours is 21, they're still young. And the second one says, the third box says, I want to ensure my children's inheritance is protected from lawsuits, creditors, and future divorces, no matter how old they are. If that applies to you, please check that box. Or if you're interested in that, check that box. That being said, how well do you know your siblings or your children? I don't know if everybody does, but there's this game called Monopoly. Am I right? I've not. It's been a long time I played it, but we used to when we were young. And in there, you play with money, you play with homes and real estate. At least I can remember that. And you can buy a house in Potomac. That's where I learned about Potomac, Maryland, Monopoly, and another place called Piccadilly. I don't know where that is. Does anyone know? No, maybe it's in UK. I don't know. But anyway, and you can get a lot of money. But do you know how much fight ensues on a Monopoly board? It's a lot. So now translate that into real life money and assets. You don't know what will happen when it comes to real life money and assets. You can't trust anyone totally. A good child may be very protective of your money and decide not to give the sibling something. Or there may be a black sheep in the family that is always fighting. Or there may be something that will sit down on someone that will just sit down on everything. Like the person I said, she thought everything was given to her because she was named the personal representative. You understand what I'm saying? So anything can happen when it comes to money and assets, but you want to control as much as possible to avoid conflict. There could be the nagging children fighting and arguing against each other, beaching against each other, the entitled 18 years old girl, you know, don't talk to me like that. The lawsuit, or maybe you have 5 children and they want to divide the house into 5 pieces. And there could be the family that are in love with each other after you. Which one do you want? A peaceful family. You don't want to leave your home or your people or your loved ones in a mess. You don't want them to be fighting after you. You're gone, but you want peace in your home and harmony among your people. So do the right things. You've worked hard. You want to give them something. People tell me, I work because of my children. Um, in my language, it's said so well, but nobody understands my language, so I wouldn't say it. But basically, say, why are you working? They'll say, it's because of my family, it's because of my children. Am I right? Now you work because of your children, you leave inheritance for them, but it's no good to them. Why? Why do you want that to happen? So, but you can prevent that by having very good plans in place that will work to avoid conflict and to avoid court. Right? So, how can you achieve that? For those who have minor children, we've spoken about not getting inheritances at 18. Another thing that you want to consider if you have any child under 18 is to have what we call a kids protection plan. So basically naming guardians for your children, both temporary guardians or short-term guardians and long-term guardians. Why do you need a short-term guardian? You need a short-term guardian in case of an emergency. Who is there to call upon immediately that has the legal authority to take care of your child in the event of an emergency? We put people's name down in school, am I right? Because the school system will ask for names. However, if something happens and the police has to knock on the door, they'll ask you what legal authority do you have to take care of this child? And if that happens, they can take the child, the recipients can take the child away until someone, maybe a legit family member, comes to take care of the child. You don't want to leave children in trauma of staying with strangers if something happens to you. So create a kids protection plan. Name who you want. The long-term guardian usually comes with a will. Do you understand? But will comes into effect after someone has passed away. And who even knows where you kept your will if you have one? Do you understand? Or maybe your family member is in Kansas City. Before they come, someone needs to take care of them, particularly if they're very young. If you have an 18 years old or a 20 years old, they probably can take care of themselves. Do you understand? So if you have grandchildren or if you have children with children, please tell them to set up a kids protection plan for their young ones. All right? And we do that. Not a lot of attorneys have that in place, but we help our clients to get that sorted out. We also want to speak about power of healthcare directive. So it's another legal document. It's separate from the power of attorney. This one has to do with healthcare. We spoke about self-care before, am I right? So you want to turn your healthcare wishes into directives. You want to be able to say who your healthcare agent is, so that if you're in a position that you cannot make healthcare decisions for yourself, you've already nominated someone to make the decisions for you. Why? Because if you don't nominate someone, the doctors will try, and there also may be conflicting interests. There are also some decisions that you need to make or you should make. They're very sensitive decisions. Decisions like life support, DNR. Do you understand what I'm saying? So, nobody wants their loved ones to go anywhere. Well, a lot of people don't. But there's some people that are very logical and they don't really care. So, if you have more than one child and you're in a situation where you have to be on life support and then the doctor needs to make a decision about what next, one child may say, I don't want mama to go. And the other child will say, she may constitute a burden. Am I right? But mama is not in a position to say what they want anymore because they don't have a healthcare directive in place. So you need to make such sensitive decisions by yourself so that you're just giving directives on what you want. There's some people, I have spouses that come to me, one will say, no life support. And the other will say, I want life support as long as possible. Because we have different ideas and different needs and wants. But if you leave that decision for your children or your spouse, they will make their own decisions, not yours. You don't want that to happen. So have that in place to avoid conflict and to avoid confusion. That's a picture of Terry Scheibel. Who knows her stories in the early 90s? So Terry became brain dead and she was in a hospital on life support. She had a husband and she had two parents. There came the decision on whether to pull the plug. The husband said yes, you can go ahead to pull the plug. The parents said no. These are two loved ones, but she didn't tell anyone in writing. She doesn't have a healthcare directive that says this is who I want to make decisions for me. Some people think it's default. Am I right? Some people think, oh, automatically your husband should make that decision. Am I right? That's why some people don't make them, but not everything is automatic. So, that being said, the loved ones were loggerheads because they had conflicting views. At the end of the day, it became so bad that they had to file a lawsuit. They filed a lawsuit, and the judge made the decision at the lower court. Someone was not pleased with it, filed an appeal. And they kept on filing an appeal and filing an appeal until it got to the Supreme Court. That case used 10 years. There was 10 years of litigation. And finally, and it got also to Judge Bush's attention. Do you understand? That it became so bad that it became of national importance. At the end of the day, there was a ruling that she should be taken off life support. Do you know how many hundreds of thousands of dollars went into litigation? And how many bad bellies and conflict happened in the family among loved ones because someone refused to make decisions ahead? And I think she was probably in her early 30s when this happened. So, It's not too early to have all these estate plans in place. It's not too early to have a power of attorney. It's not too early to have a healthcare directive. Do you understand what I'm saying? Make sure you put these things in place to avoid conflicts, to avoid court. And your decisions will be the one that will be implemented, not their decisions. You understand? And I even have someone that in a healthcare directive did not nominate a husband as a first choice of agent because she thinks her husband doesn't really understand health. And she has a friend that is very health conscious, and she chose a friend to be her first choice of agent. So do you know that, what I'm saying is that make your choice. Don't let another person be making a choice for you. All right. So would you like to have a situation where you have all this in place so that your healthcare decisions and choices will be honored, and your wishes will be turned into a directive? If your answer is yes, can you check that box that says, I need to have a power of attorney or a healthcare directive? I need to review them. If you have one already, maybe you need to review for the purpose, for all, the reasons I said, review your plan. Please check that box if you think it's important to you to have a healthcare directive or a power of attorney. So we've been speaking about having a will, having a trust. You've had this trust. So, what type of trust are we really talking about today? It's about a trust called revocable living trust. Everybody say revocable living trust.
Revocable living trust.
All right. A revocable living trust is a legal document, like an agreement. It's an agreement that makes you're the owner of your assets. So you are the trustor or the owner or the settlor or the grantor, whichever word you use. And you are the trustee of your assets. That means you manage your assets. And then while you're alive, you are also the beneficiary of your assets. And it's a legal document that the law recognizes. All right. So, but what happens is that instead of your assets being in your personal names, it's in the name of your living trust. All right. But you don't just have a living trust, you have to have a fully funded living trust if you want to avoid probate court. Everybody, please say fully funded living trust. Okay. So some people produce just documents. So you go to a traditional lawyer or you go online and you want to create documents for yourself. You have the documents, but the document may not work when needed because they won't tell you or they won't teach you how to fund the trust. All right. So someone actually paid a lawyer $3,000 to have a trust created, but he wasn't advised to fund it. I have a few people come to me from time to time that they've created estate plans, including a revocable living trust. But what does a traditional lawyer do or the general practice lawyer do? Created some documents, or what did Susie Ullman do? They self-created a document called DIY, do it yourself, signed it and put it somewhere. Or bad still, or worse still, they don't even sign the documents because they don't understand the content. And if the legal documents are not signed, they're not effective. They have to follow some protocols to make them effective. So a lot of people self-create documents or use quack attorneys, not quack, but people that are not specialized in this thing, to create legal documents that are not effective because they don't have the system in place to make it work. I know someone that did not have any asset that was told to create a trust. No, not everybody has an asset, but she was told to create a trust, and the trust was just in a folder, unsigned for years. So this man paid $3,000, created the trust, and when he passed away, the family still had to go to court because it was not funded. And the children wondered, but our dad tried to do this thing. Why are we still having to go through the court system? But you know why? Because it did not transfer his assets into the trust. Funded means transferring your assets into your trust from your personal name to the name of your trust. All right? So he did not do all that. And to make matters worse, he used to be married, and the wife had some gifts that he was going to give her. And the wife was also named as a trustee, a successor trustee. Unfortunately, they got a divorce, and he did not make a change into his trust. So the wife fought tooth and nail to get that gift that was given to her in the will. Will she get it? She will, because it was given to her. So review your plans. Fund your trust if you have a trust. Anything in your personal name will take your assets to probate. Okay? If it's in your joint name, in a joint name, like couples have homes in joint names, am I right? If one person passed away, it goes to the surviving spouse, depending on how titled. If it's titled joint tenancy with right of survivorship, but if it's a tenancy in common, it's separate. All right. However, a lot of people don't think, what if two people pass away at the same time? Then your assets go to probate. A lot of attorneys will plan for one person and not plan for, but it's better to plan as a couple if you're married. Okay. So, all my stories, a fully funded living trust with disability provisions protect you both while you are alive in the event of incapacity and protect your family and assets after you're gone. And it also helps avoid the court process, right? Because you've retitled your asset into the name of the trust. And it's not just retitling your home, it's doing all these things. Like you change the signature card on your bank account from your personal name to the name of the trust. You execute a new deed for your house. You retitle your investment account. You assign your personal properties to the trust. You designate beneficiaries for your life insurance and all that. We, as estate planning attorneys that know what they're doing, make sure you get all this covered when you're planning with us. So we don't just give you a document only and say, figure it out, or we don't talk about it. We make sure that if you have a revocable living trust, it's fully funded so that you will avoid court and have all the benefits I've spoken about. All right? Save time, save money, save publicity. Your children are getting things outrightly, they're getting things protected. And you're even passing generational assets. If you want things to go to your grandchildren, you can do that in a trust. Even if you want to disinherit someone, you can do that in a trust. There's so much advantage in having a revocable living trust. And what does it mean by revocable? Revocable means you can make changes. You can decide to revoke it and make a change. Do you understand? It's different from having a trust that once you execute the trust, you can't make a change. That's irrevocable. So if I give you an option, if you're looking for, if your goal is to protect your assets and your children from having to go through the court process called probate or avoid court, what you need is a revocable living trust. All right? There's some other types of trusts. The irrevocable trust, some people have those for asset protection. Those who are very creditor prone. Do you understand? They do advanced levels of planning called asset protection. But what does that mean? That means the asset is no longer theirs. So that may be ideal for some people, but the minimum you want to have, if you want to avoid court and if you want to avoid conflict, if you want to make things right for your children or your loved ones, is to have a revocable living trust, which is better than just having a will. Do we understand that? So, if you want to have a trust in place, a revocable living trust, please check that box. If it's of interest to you, check the box that says, I need a living trust. Or a will, I want to review my existing plan. All right? And here's a story of someone who did it right. She was in her 30s. Her name is Anne. She was in her 30s. She spoke with a financial advisor who advised her to have a life insurance. She began to build a portfolio. She has 2 minor children. And she also spoke with an estate planning attorney because she has a home as well, who advised her put a plan in place. So she did a revocable living trust. And she did a fully funded revocable living trust. All right? When the unfortunate happened to her, while she was incapacitated and in a hospital, she already had agents in her power of attorney. All right? So there's no need to go through the guardianship court. She had a healthcare directive. Someone was making the decisions for her. She had to be on life support. It was there that she doesn't want life support to be longer, to be prolonged more than 2 weeks. So that was honored. Unfortunately, after 2 weeks, Anne passed away. When she passed away, in the interim, because she had a kids protection plan, our children stayed with our neighbors who were assigned to be short-term guardians. They didn't have to go through to CPS or foster care. They didn't have to be taken out of with the government or police. She also had a long-term guardian who was the person that would take care of the children after a death. So the children went with a sister who was out of state because as our out of state sister was nominated as the long-term guardian for children. She also had instructions on how she wanted her children to be taken care of. So the children had a smooth transition without the court's involvement. There wasn't a need for a custody fight because she had more than one sibling. She had an ex-husband that was an alcoholic and a substance abuse person. Things were settled. Now, the life insurance and all the assets she had, our kids are minor children, they were put in trust because she left it in trust for them. So someone who was a trustee was managing those monies for them until they turned 18, or not even 18, until they turned 22, because that was the age that she says you can become a co-trustee at 22. And this is how much you should have at 22. This is how much you should have at 27. This is how much you should have at 35. And she had a trustworthy person taking care of this for them and not putting those monies in her pocket. Some people have life insurance someone called Xavier. He was divorced. He had a life insurance and changed the name of the beneficiary from his spouse to his son. Am I right? So, because she didn't want the ex-wife to be a beneficiary anymore. He also named his brother as a beneficiary. When he passed away, the life insurance went to his brother. And whose money is it? The brother's money. And if the brother wants, he can use it to take care of the child. If he wants, he decides that he cuts the shot, calls the shot. So some people try to plan, but when you use an attorney, you plan better. So Anne did a good thing, and she did not leave a mess for our family because she had a plan in place, and a plan worked when it was needed. So, if you want to avoid estate taxes, because we spoke about that, that can be done with having a trust in place. Because you can plan in such a way that your children's inheritance is set up in trust after you. Or even your spouse, whatever goes to your spouse is set in a trust rather than going to them outrightly and they get taxed. All right? And even if you have a lot of money, because I told you about estate taxes, am I right? You get taxed any which way. We have vehicles to make sure that taxes are minimized, and that can be accomplished with having a trust in place. I don't know if you know Prince, but he had so much money to pay after he passed away because he didn't do a good plan for himself. Alrighty. When do you need a will? When do you need a trust? So if you have assets over $50,000, under $50,000 is a small estate for one person. Over $50,000 takes you to regular estate. You may want to have a trust. A lot of people have homes here. If you have a home, you may want to have a trust and not a will. Okay, because that takes you over the $50,000 mark. If you have minor children, rather than just have a will, which gives things to them outrightly and unprotected, you want to have a trust. If you have a blended family, you want to have a trust. I spoke about the story of someone that did not allow a stepchild to see the mother. So let's assume that the mom passed away and the husband got the boilerplate will that says, I give everything I have to my husband. Am I right? The husband got everything, but he had a stepdaughter. Am I right? Now the husband remarried and he made a new estate planning document, made a new will, and said, I give everything I have to my children, the children. Do you understand? And his new wife. When he passed away, everything the first wife had with him went to his own child and his new wife, and not the child of the first spouse. Is that what the woman wanted? No. That's how you can inherit your children, your stepchildren, or your children that are born out of wedlock. So if you have a blended family, have a trust and plan for those people exclusive of. You understand what I'm saying? Also, if you have children with special needs, you want to have a trust. If you have children that have special substance abuse problems, you want to have a trust because they may not be financially mature or they may just squander the money. And if you have a business, how many of us are business owners here? If you are a business owner, you want to have a trust because you want to put your business in your trust. All right? So these are some of the reasons why you may need more than a will, called last will and testament. you may need a trust. So we're almost wrapping up our conversation, but I hope you've gotten a lot of understanding and education around wills and trust and what you need and what you need to do. Am I right? All right. So the title for today says how to avoid, 3 mistakes that people make in estate planning. How do you avoid them as well? I want to ask you this question because I've been doing a lot of talking today. Please help me identify 3 mistakes people make when it comes to estate planning. Yes, ma'am.
Not keeping their estate plans updated.
Not updating their estate plans. Thank you. If you're online, please help me type the plan the mistakes people make. All right. Another mistake,
Not using a lawyer.
not using a lawyer, trying to create the plans themselves or online. Thank you. Yes, ma'am.
They die.
The die without plan. Thank you. Any other one?
Not putting your estate planning in writing.
Not putting your plan in writing. Holographics. No, that's even not just having your plan in your head. Am I right? People plan in their heads and don't put it in writing. Thank you, sir. Is there any other person that wants?
The fully funded. The fully funded.
They don't have a fully funded living trust. Thank you. Thank you so much. I have a very intelligent set of people right here. Thank you. And how will you avoid all these mistakes? That's everything we've discussed today. Have a fully funded living trust. Marshal your assets together so there's no loss to the government. Choose people that you know, like, and trust so that the judge is not choosing people for you. Make the decisions by yourself so that the decisions are not made. Don't unintentionally disinherit your family members and don't lose money unnecessarily to the government. Alrighty? So, we want to help you take the next step. If you checked your green sheet, you probably checked some things. Those are the things that you need to take care of. All right? So, what's your next step? We can help you start to put your estate plans in place at Ivy Law Office. And we start by what we call a family wealth planning session. Someone say family wealth planning session.
Well,
Planning session.
So, some people say consultation, but it's a strategy session for 2 hours. It's a 2 hours meeting with an estate planning attorney. All right? When you sit down with me, that's the complimentary meeting I was talking about earlier. We talk about you, your assets, your family, your wants, not Staples want, in that Staples form, not the boilerplate legal Zoom want, your want. And we're able to see what gaps there are. What do you want to happen? What will happen if you don't have anything in place? And we'll try to close the gap. All right? In the family wealth planning session, one of the important things you will take away is that you'll get more financially organized than you were before. Because before you come, we're going to give you an intake sheet. We call it family wealth inventory and assessment. And we'll ask you to complete that before you come to the meeting. Complete and submit 3 days before the meeting. That gives you an opportunity to pull your assets together and know what you have and think about what you have, your family members, your loved ones and things like that. Now, when you come for the meeting, we're making an efficient use of our time, all right? And we're making decisions promptly and faster. So you get more financially organized. And also, your assets will not be lost because you've pulled them together into writing. When you come for the family wealth planning session, today, if you submit your green worksheet, we're going to give you a $750 gift certificate towards that session. So please do submit your green worksheet, okay? This will help you. The session is valued at $750, but we can give this to you. Number one, when you schedule and secure your spot on our calendar with $20. All right. And number two, you make a commitment to complete your intake and submit it 3 days before the meeting. All right. If you want to make use of this gift, pick up this $750 gift certificate and submit your thing. But if you're not going to complete the intake, the value that you're going to pay is $750. All right, but you make a $20 deposit today to get on the calendar. Is there any question about that? All right. Also, when you schedule your family planning session today, we'll give you two additional gifts. Gifts. One is a $250 gift certificate. The $250 gift certificate is for you to apply towards any plan you choose when you engage us. Right? Either a wealth plan to make a trust or a trust plan to make a trust. We'll give you a $250 credit. All right? We'll also give you a digital asset checklist when you schedule a family planning session with us today. If you're still thinking about it, schedule a callback appointment, okay? And we'll give you a 15-minute callback meeting. So on your green worksheet, you have the third section that says next step. It says, please call, schedule a family or planning session. You want me you want to be contacted for a callback? Check whichever box. But we want to make it easy for you and would like you to schedule a session. If you're a couple, you come as a family. All right? During the session also, you'll make informed and empowered decisions. You'll be able to choose the level of planning that is fit for your family. And you'll be able to work on flat fees. We do flat fees for estate planning in our office and not hourly fees because we want to make it comfortable and affordable and no surprise. Do you understand? A lot of lawyers' office, you pay hourly fees. You don't know how much it's going to cost at the end of the day. But when you have a flat fee, you work with more certainty. Am I right? So we offer that our services at flat fees for you. And also you receive expert guardians because you have a trusted estate planning attorney that will guide you while you're alive and will guide your family when you're gone. So there's so much value in having a family wealth planning session, and we want you to take your next step today to get it started. So, do not procrastinate. One of the things that happens to people is procrastination. I'll do it tomorrow. I'll do it next month. I'm doing a project now. I'll do it after the forget. But the forget that tomorrow never comes. When it's tomorrow, then there's another tomorrow. So don't procrastinate. Don't leave your families at risk. All right? Take a step now to get it started, particularly if you're convinced today that it's something worthwhile that you need to do. First of all, for coming here today, that means you're interested in learning more or taking the next step. So please do. One of my mantras this year is this: just do it. All right? So just do it. If you're thinking about it, just do it. Don't procrastinate. So go back to your first questions. The first question says, who do you want to protect? What needs your protection? Are they still the same people and the same answers? Yes. So we spoke about this already, and this is how you do it. This is how you just start. Go to the back of the room and schedule your family wealth planning session. Remember to pick up your gift card certificates, and this is our contact information: 301-276-0887, or email us at csd@ibellaoffice.com. If you're not scheduling today, if you want to call back. If you're online, please contact us by giving us a call at 301-276-0887. We're glad you joined us today. We hope this is very informative. We hope this is very educative. We hope it was worth your time. Thank you very much. And now we're open to questions. Any questions?
I got a list of them, so if you don't mind, I just want to go through mine and maybe some of the questions that I have may answer some for somebody else.
All right. Sorry, we're out of 12 o'clock. Can you give us a few more minutes? Thank you.
So one of the things for my personal situation, my dad is one of these real old school type of people. He think I'm the only child, so his response to me is, "They'll find you. They'll find you."
They'll
Meaning
find you
he
because you're the only
believes that
child.
I'm, going to inherit or
Everything.
everything is going to come to me. I don't believe that, and I don't know how to convince him that he really needs to do a will or do something because he does have assets. And I mean, okay, you dispel that myth.
So do you know everything he has?
I do not.
Exactly. A lot of things will be lost.
Right.
Even if you will know when your father passed away.
Right.
Am I right? But you will lose a lot of things to outsiders because you don't know everything he has.
Right.
And you'll go through the gruesome process of not only mourning his loss, but at the same time having to go through probate process.
Right.
So if he loves you so much and wants to keep you out of the mess, then he needs to do something.
So what would be the difference of him just putting together a list of all his accounts, debts, whatever, me and telling me where that is versus having to go through a formal will or trust?
If he doesn't have anything, and he does that, at least you won't lose the assets, but you'll go through the court process, probate, and you'll spend a lot of money and a lot of time getting what is left for you. Is that what you want?
No, of course not.
You can do better. Tell him that.
So one of the other questions, personal issue for me is if I have a will or trust rather, but there are debts or taxes that may be an issue. How is that worked out, or so that my children don't inherit that, or the government doesn't take that situation?
Okay. So a lot of people think when people pass away, their debts vanish. Not necessarily. Okay. If you have assets that will pay off that debt, the ideal thing is for you to pay your debt in taxes. Do you understand? And even the first line, or one of the first few obligations of a personal representative in a will, is that make sure you pay off my debts and the taxes and anything that is due. All right. So you will still have to pay that. Did I answer that?
Yeah. And I just had one other thing is it ever the right thing to do to convert a trust to a will? Just a question. I mean, I went through and I saw everything you said, but I'm just, based on what you were saying, is it ever a right thing to convert a trust to just a will?
So let's say there's some people that have just exclusively non-probate assets. Let's say you don't have a home, you don't have children, you don't have assets up to $50,000, then you may not have need for a trust anymore. Am I right? And maybe your bank account doesn't really have any money, or maybe you've named beneficiaries in your bank account. Do you understand? You stop. If you have exclusively non-probate assets, then maybe you want to think about that. But if you have probatable assets, you have to do better for yourself.
I'm good.
That's it. Any other questions?
Where do you recommend keeping a will
Okay.
or a trust?
Or just so a lot of people think about when they create this legal document, they keep it in their attorney's office. Am I right? But none, you don't have to keep it in your attorney's office. We give the originals to you. You can keep it wherever you keep important documents, in a safe. You can keep it in a safe deposit box. If you just have a will, you can keep it in the courthouse as well. I've even had someone that kept their legal documents in a freezer. So keep it in a safe place and let someone, one of the agents, know where it is. That's it. Yes.
So does the estate planning laws differ in different states?
From state, so estate plan is governed, it's a state law, okay? So the plan in Maryland may be different from the plan in New York. So when you're in Maryland, where you make a plan is where you live, where you have assets, all right? That's where you make your plans in. But people move. You can decide to be in Maryland to then be in Florida tomorrow. The law of Florida in Florida may be different from the law in Maryland. Okay. So when the answer is yes, but when you make an estate plan and you move from one state to the other, you go to the estate planning attorney in the new state and say, can you review my plan to make sure it's compliant with the laws of the state? Do you understand? And then make any change that is necessary. However, things are better today because they realize that, and there's something called uniform estate plan. Okay? There's a uniform rule that needs to be followed, that can be followed now, that makes the states that are part of that uniform law comply with the requirement, so that when you make a state when you plan an estate in Maryland, you can make use of it in DC or in Pennsylvania. You get what I'm saying? So there's a uniform estate planning rule that can apply now.
So the reason I ask is I want to do estate planning for myself and my mother as well, but she lives in a different state.
So if your mom lives in a different state and she has assets in a different state, I'll advise that she gets a plan done in that state.
Okay.
Yeah. And you get yours done in Maryland. And we have a network of attorneys that can do things right the way I'm soliciting or advocating. So I can check if there's a lawyer that I can refer you to for your mom. Okay.
And I just had one other question. Because by the way, you did a great job with your presentation. So
Thank you.
a lot of things going through my mind. If today, that's one of the things where you say, if you don't schedule the family well planning session today and you ask for a follow-up call later, so you still get the opportunity to use the gift certificate, or is it only while you're here today?
So you have to schedule a family well planning session before March 31 to be able to use the $750 gift certificate. Okay? But schedule it today. All right.
Thank you.
Yeah.
question. A lot of people advocate, putting beneficiaries on life insurance policies or payable upon death on your bank accounts. Are there any pitfalls to doing that versus having everything go into your trusts?
That's a good question. So the question says a lot of people name beneficiaries on their life insurance or on their bank accounts, payable on death bank account, as a way of planning. All right. Is there any pitfall to doing that? So if you don't have a lot of assets, you can do that. And if you don't have a lot of people have complex lives. All right. But the pitfall is this: what if something happens to that beneficiary? Do you understand? Then it's as if you did not plan, and it goes to probate. So when you're working with us, we're thinking far and wide in a comprehensive way. We're not just doing one level planning or one layer of planning. We're doing 2, 3 layers of planning to make sure it works. So, any other question?
I have one more. So I know you've worked with a lot of different families, have seen lots of different power of attorneys, personal representatives. In making that decision, is there like a list of characteristics that you would prefer? Like when we're considering who do we choose? Like, how do I make this decision? I know you talked about the monopoly game, but beyond that, like in terms of personal characteristics, traits, how would you advise me to select someone?
So there is no list of how, but those duties are fiduciary duties. Okay, fiduciary duties means you have an obligation to meet all these requirements. So first of all, the person needs to be someone that cares about you. The person should not be lazy, so that they'll be able to take care of your needs. The person needs to be able to be educated enough to be able to fill out paperwork or layers with an attorney that will help them. The person needs to be responsible financially, because a lot of finances will be committed to for them to manage. Their trustees. Am I right? So those are a few. Then of course, know, like, and trust those people. So those are a few of the things I'll say. Is there any question online?
The only question that I see here says, how often do I review my plan if I have a plan in place?
So we recommend that you review your plans every 3 years if you have a plan in place. And the reason we do is this: life can change, your beneficiaries can change, your agents can change, your assets can change, and the law too can change. So review your plans at least every 3 years. If there's nothing to change, there's nothing to change. If there's something to change, you know you're up to date. All right. Does anybody have any lingering question before we wrap up? Yes.
Let's say if your parents live do something in a different country. Let's say they have a house in Lekki Phase 1, and then they have a house in Maryland. How do they inherit the one in a different country? Or will
Okay.
they need to hire different lawyers?
Yeah, the answer will be yes, because where you domiciled and where your assets is located is the law that governs it. All right. So if you have a home in Maryland, the law of Maryland governs the distribution of that asset. If you have a home in Lekki, Lekki is in Nigeria, the Nigerian law will govern it. All right.
Does it matter where you born or where you currently live? Or if you have
Where
a
you
home-
live, where you live,
Okay.
where you live. So, and where you have assets, where you live. So I live in Maryland, I work in Maryland, I have a family in Maryland, I pay taxes in Maryland. If I pass away, Maryland law governs what I have here. What I have, if I have anything outside the country, you need to speak with the lawyer outside the country to make sure those are also covered. However, because we have some clients that have assets in different states and different countries, we still put that in consideration in the trust, at least to make sure that the beneficiaries know what they have and where to find it. So that's part of why we do the inventory, so that the out of country asset doesn't get lost. And we advise them on what to do to make sure it's all accounted for. That's a good question. Thank you. All right. Sorry that we went beyond our time.
One last thing, piggybacking off what he said about the certificate, is it transferable? Like,
What?
say, is the certificate transferable? Like, if I want to give it to my dad because I did this and I know he needs
You
it,
did this for your dad. Bring your dad. Come with your dad so that I'll know it's from you. All right. So, and come with your mom. All right. So thank you so much for your time with us today. I hope it was worthwhile. Thank you for participating. Those were beautiful questions. And the next step is
Turn in the green sheet.
just do it.
Oh.
Schedule a family wealth planning session. Can you please clap for yourselves? Thank you. Thank you for those online. We appreciate you participating in this. Have a beautiful weekend. Bye. God bless you all.
When will you give this up, your session again?
So we have this like everyone else.